Hello, my name is Toby Craddock and I am a member of the family team here at Dean's Court Chambers. This is our second series of seminars which have been developed to ensure that you're kept up to date with all the most recent developments to case law and procedure in family justice. Today I'm going to be talking to you about how the court approaches reopening finding of fact hearings. We're going to be talking first of all about the general principles that apply to finding of fact exercises before turning to the case of CTD, a child rehearing, which is a Court of Appeal decision handed down in October of last year. And then we're also going to be looking finally at how that case has been applied subsequently in a private law dispute. Starting off with those general principles then, what is a finding of fact hearing? Well, it's a hearing that the court considers whether or not to determine factual allegations. Has something happened? What has taken place? In public law proceedings, an example would be in a case of non-accidental injury where a local authority alleges that a certain individual has inflicted injury upon a child. In private law proceedings, one would often see at a finding of fact hearing allegations being raised by one party against the other that they have perpetrated physical, emotional or sexual abuse upon them as part of a domestically abusive relationship. The burden of proof always rests upon the person who asserts that their allegation is true. The respondent to that allegation does not have to prove their innocence. The standard of proof to be applied is the ordinary civil standard, which is, of course, the balance of probabilities. So the court simply has to be convinced that more likely than not, this allegation has taken place. Whenever you are reading a judgment in a finding of fact exercise, you will often see references to this particular metaphor, the wide canvas or the broad canvas of evidence. It's frequently referred to because it's a helpful reminder that in determining a factual allegation, we shouldn't focus on one particular aspect or detail in the evidence. We need to take a step back. We need to survey the wider evidential landscape and consider the evidence in its totality. Mr. Justice MacDonald, in the case of Re P last year, reminds us and extends the metaphor of the wide canvas that the threads of the canvas are woven only through relevant and admissible evidence. If there is evidence which is irrelevant or inadmissible, then it can't form part of the court's consideration. The court, however, is not limited to only considering what the evidence tells them in black and white. They're not limited by that. They are permitted to draw inferences where it is reasonable and proper to do so. It's not to say, however, that a finding can be made on the basis of speculation or suspicion. There does need to be more than that. Re B, care proceeding, standard of proof 2008 from the House of Lords. And at paragraph 32, Lady Justice Hale reminds us that in our legal system, it is a binary system. There are two possible outcomes and only two possible outcomes. Facts are either established or they are not. The judge is not allowed to sit on the fence. The judge has to find for one side or the other, which is, of course, one of the main reasons why lots of people want to consider reopening finding of fact hearings, either because the court has not made the finding that they want, or because an adverse finding has been made against them and they are maintaining their innocence. CTD. This is the most recent and authoritative restatement of the law in relation to reopening finding of fact hearings. It is a wonderful judgment. The first 13 paragraphs of Lord Justice Peter Jackson's leading judgment in the Court of Appeal effectively form the basis of your skeleton argument when you're asking the court to reopen finding of fact hearings. There is a 3-stage approach. Those stages must all be met. They can't be skipped. If you fail or fall at the first hurdle, then the finding of fact won't be reopened. I do go into more detail about the facts of this case, the grounds of appeal, and why Lord Justice Peter Jackson made the decision which he did in CTD in the article which was included in the most recent Dean's Court Family Team newsletter, and I would encourage you to read that alongside watching this seminar. In the spirit of summarising the case of CTD, here are the 3 stages which I've just referred to. 1. Effectively, do those previous findings require revisiting? If you pass that, you move on to stage 2. How is the rehearing going to be conducted? And then stage 3, the rehearing itself. Stage 1. From paragraph 3 of CTD, Lord Justice Peter Jackson tells us that any decision to allow past findings to be relitigated must be a reasoned one, which begs a question: what are the reasons that are going to allow you to make that decision, Judge? First of all, will reopening the case serve the child's best interests? Secondly, will the findings have a material impact on the current proceedings? Well, we're all familiar with the best interest decision, but in terms of whether there will be a material impact or not, I'm reminded of the other leading judgment given by Lord Justice Peter Jackson in the case of Re E from 2019, in which his lordship says, is it likely to have a significant legal or practical difference to the arrangements that are to be made for these children? The citation for that is on the last slide. And finally, and most importantly, are there solid grounds for believing the rehearing will result in a different finding? And from CTD we know that mere speculation or hope that there will be a different finding at the end of a rehearing is not sufficient. You need something more solid than that. Stage 2 is how the rehearing is going to be conducted. Do we start from scratch? Well, if you don't need to start from scratch, if there's only a particular part of the evidence which requires revisiting, such as in a non-accidental injury case, evidence of the medics, then it wouldn't make sense in that case for all the lay parties to have to go through the process of giving evidence again. It needs to be proportionate. And as Lord Justice Peter Jackson reminds us, if stages 1 and 2 are properly adhered to, then the right balance will be struck between preventing unmeritorious attempts to relitigate settled findings, whilst allowing cases that genuinely require reconsideration to be identified and revisited. Stage 3 is the rehearing itself. It is not a review. It is not an appeal. The judge must consider the evidence afresh, so they can't give presumptive weight to earlier findings. And if the judge is not satisfied at the end of the rehearing that the original findings should not be set aside or varied, or no additional findings should be made if that's what is being sought, then the findings stand unless they are shown to be wrong. One of the reasons why I particularly enjoy working in family justice is because in our world, the case law develops at such a pace that no sooner is it handed down than we can see it applied. And Riel is a perfect example of that. CTD was handed down in October 2020 and Riel was handed down applying CTD only 2 months later in December 2020. This is a private law case. CTD was a public law case, and the judge who handled Riel was Mr. Recorder Howe of Queen's Counsel, and he was sitting as a deputy judge of the High Court. Interestingly enough, Riel wasn't originally going to consider reopening a finding of fact exercise. It was supposed to be a straightforward, or as straightforward as you can be in the High Court, welfare hearing, a final welfare hearing in private law proceedings. Findings had previously been made against the father in February 2020, and the judge at that hearing had determined that he had subjected the mother to physical, mental and emotional abuse, and he'd effectively stranded the mother and the children in a foreign jurisdiction by returning to the United Kingdom with their travel documentation and their passports. It appeared to the recorder, when he was hearing evidence from The Guardian and when he was considering the papers, that the father's case, which was for contact, he wanted to exercise contact with the children, was being run on the basis that he disputed the findings that had been made 10 months before in February. It should be pointed out at this stage that father was represented in February, as was the mother, by counsel. But at this hearing before Mr. Recorder Howe QC, father was now a litigant in person. Mr. Recorder Howe QC wanted to afford fairness to all the parties and asked the representatives of the mother and the children as to whether or not he should, of his own motion, treat the father as making an application for review of the findings, because as litigant in person he wouldn't be aware of CTD, and he also wouldn't be aware that in pursuing a case for contact on the basis that findings shouldn't have been made, that he couldn't do that without having those findings set aside. Neither the mother nor the children objected to Mr. Recorder Howe QC considering whether or not the findings needed to be reopened. Father fell down at the first hurdle. The only new evidence that he sought to adduce from the February hearing came in the form of 3 witness statements from individuals who asserted when they visited the family home that they saw no evidence of domestic abuse. Father, of course, had been represented in the February. The witness statements described events that had taken place before the February but hadn't been relied upon, and these witnesses hadn't been called. Not only that, but these witnesses were only speaking of what they saw on a number of opportunities when they visited the house. Mr. Recorder Howe QC considered, in reaching a very clear conclusion, that the father raised nothing that can be properly characterised as a solid ground for revisiting the findings reached in February, because those statements ultimately didn't exclude the father from having the opportunity to commit acts of domestic abuse against the mother. They only referred to selected opportunities when these people visited the household. So, that is a whistle-stop tour of reopening finding of fact hearings in public law and latterly private law proceedings. Here are the cases which have been referred to: Re B, care proceedings, standard of proof; CTD, a child rehearing; Re E, children reopening finding of facts; and Re L, children, domestic abuse, stranding, abandonment. I hope you found the seminar useful. It will be available on the Dean's Court Chambers website, and we hope to see you soon at the end of this lockdown.